Interpretation of statutes. Statutory interpretation is used when the meaning in law of an act of parliament or another piece of legislation must be determined. Words can be ambiguous or imprecise, despite careful drafting of the acts, and then various theoretical rules and methods are used to interpret what the statute seeks to achieve. This is not vague guesswork or a subjective interpretation of what the law should be. Rather, this exercise has been defined as a dynamic and functional process through which the text of the legislation and the contextual factors surrounding it are objectively researched to determine the purpose of the legislation and give effect to it in the light of the principles prescribed by the Constitution. 1.5.1 The relationship between the stare decisis rule and the interpretation of statutes. South Africa's tripartite separation of powers has the result that, theoretically, Parliament makes laws while the judiciary applies them. But nothing is ever quite that clear-cut. A study of the stare decisis rule will have shown that one of the sources of law is the decisions of the judiciary on what the law is. So an interpretation by a court of the meaning of a piece of legislation, coupled with the precedent system, means that other courts are bound by that legislation as interpreted by the court, until a superior court places a different interpretation on it, or the legislature amends it. This does not mean that the courts determine statute law. Their function is to interpret and apply a statute without amending or altering its provisions. It does, however, mean that a lower court applies a higher court's interpretation of the wording of an act, rather than applying the wording of the act itself. 1.5.2 The influence of the Constitution on the interpretation of statutes. Before the advent of the Constitution, statutes were interpreted according to the provisions of the Interpretation Act 33 of 1957 and set rules and principles deriving from common law. The Constitution is now the fundamental and supreme law of the country, and any statute that conflicts with the Constitution, whether promulgated before or after the Constitution, can be declared invalid. The Constitution also sets out guidelines for interpreting statutes so as to determine whether they conflict with the Constitution. Most importantly, Section 39(1) states that, when interpreting the Bill of Rights, a court must promote the values that underlie an open and democratic society based on human dignity, equality and freedom, must consider international law, and may consider foreign law. Courts are instructed to look outside the words of a specific statute when trying to determine its purpose and meaning. The values and norms on which the Constitution is based must now be taken into account. Section 39(2), then, provides that, when interpreting any legislation, a court must promote the spirit, purport and objects of the Bill of Rights. In addition, Section 233 states that, when interpreting any legislation, every court must prefer any reasonable interpretation that is consistent with international law over any alternative and inconsistent interpretation. 1.5.3 General Principles. Two of the most important other principles when interpreting legislation are: the meaning of a provision must be determined by its language and its context in the legislation read as a whole. Any reasonable interpretation of a provision that is consistent with the purpose and scope of that legislation must be preferred over any alternative interpretation that is inconsistent with its purpose and scope. 1.5.4 The Interpretation Act 33 of 1957. The Act applies to the interpretation of every law. It contains general definitions of terms frequently used in legislation, rules about gender, the masculine includes the feminine, numbering, calculation of time, measurements of distance and the commencement and repeal of legislation. 1.6 Court Judgments. 1.6.1 Ratio decidendi. The most important part of a judgment is what is called the ratio decidendi. Ratio decidendi literally means the reason for the decision, and it is the ratio decidendi of a case which is binding, and which is the subject of the doctrine of stare decisis. As indicated, the actual parties to the case are bound by the decision. But if entirely different parties involved in a similar set of facts come before the courts will, as a general rule, follow the previous decision and its ratio decidendi. In other words, when it is said that a decision is binding, this does not mean that every sentence uttered by the judge in deciding the case must be considered as imposing a rule of law. The first step is to determine the material facts on which the judge based the decision. This is not such a simple task, but once the facts have been determined, the ratio decidendi is the conclusion reached by the judge based on these material facts and by excluding the immaterial ones. 1.6.2 Obiter dictum. The ratio decidendi is binding on subsequent courts. Competent authority. It may be encountered when the principle of the case is formulated by the judge more broadly than is necessary to cover the facts, when the judge makes an incidental remark, postulates and answers a hypothetical question, raises an analogous case or gives an illustration. Suppose the hypothetical question actually occurs at a later date. Is the next judge bound by the opinion expressed by his or her predecessor? The answer to this is no. Any remark which is irrelevant to the immediate settling of the dispute is obiter, by the way. It does not form part of the ratio decidendi and is not binding on subsequent courts, because it cannot be ascertained whether this particular point was properly argued and whether its full implications were properly considered. One could also say that the reasons given by a judge in a minority judgment are obiter, since they are not an essential link in the process which leads to the ultimate conclusion. Any obiter dictum, although not binding, may, of course, have strong persuasive authority. Once such an obiter dictum is actually applied by a later court, it thereby becomes the ratio decidendi of the later decision and thus becomes binding. 1.6.3 Distinguishing. A judge distinguishes one case from another by deciding that the ratio decidendi of a previous decision is not binding on the case before him or her and, therefore, that the ratio decidendi of the first case does not apply. It is thus a technique which is used by a judge to avoid the binding force of an earlier ratio decidendi. This may be done in various ways. The later court may, for example, be of the opinion that the earlier court formulated a principle too broadly, that the consequences are unacceptable, and, thus, that the facts of the latter case are not covered by the principle. The later court may also find that the earlier court did not take sufficient account of a fact which would have led to a different ratio decidendi, and, for this reason, may not follow the earlier decision. Or the later court may accept the earlier court's views and ratio but may encounter a material fact which was not present in the earlier case or find a fact in the earlier case missing from the latter case, hence, the two cases would not be identical. It is only when two cases are identical regarding the material facts and the points in issue that it is impossible to distinguish the one from the other. 1.6.4 Typical aspects of a judgment. In order to illustrate the most important aspects of a judgment, we refer to a case published in the South African Law Reports, National Sorghum Breweries Ltd v Corp Capital Bank Ltd 2006, 6, SA 208, SCA. The name of the case contains certain information. The applicant, claimant or appellant in the case is National Sorghum Breweries Limited. The letter V stands for versus, meaning against. The name of the defendant or respondent, that is, the party against whom the case is brought, appears after the letter V, in this case, Corp Capital Bank Limited. This is followed by the numbers 2006, 6, which mean that the case is reported in the sixth part of the 2006 law reports. SA means that the case is reported in the South African law reports, while 208 denotes the page number on which the case is reported. SCA means that the case was heard in the Supreme Court of Appeal in Bloemfontein/Mongamang. Sometimes, when a case is cited, more numbers, for example, 5 or 210D, are quoted after the division of the court. This number refers to the specific paragraph or page in the report where a particular statement appears. The case was heard on November 21, 2005 before Deputy President of the Supreme Court of Appeal Mpoti, Judges of Appeal Nugent and Jafta, and Acting Judges of Appeal Combrink and Meyer. Judgment was delivered on February 23, 2006. The names of the advocates are also given. The letters SC after the advocate's name stand for senior consultants and indicate that the advocate is a senior counsel. After this information, a somewhat cryptic resume of the case, the so-called fly note, appears, which is of little value except to someone who wishes to find out what the case is about in bare outline. In this instance, the case is about the interpretation of a contract. A reader whose subject is commercial law will peruse the report, but someone interested in criminal law, for example, will read no further. The headnote follows in small print. This is a summary of the gist of the judgment, the material facts, if they are of importance, the principle applied, and what was decided. This summary is made by the editors of the law reports. It has no official status and is only an aid to reading the judgment. Sometimes the word assemble or a letter appears, followed by a statement. Assemble means this appears to be the case according to the judgment, although the point has not been settled, for example, because it is obiter or because there is strong authority against it. A letter literally means otherwise, and suggests that the decision would be different if the facts mentioned were either added or fell away. Followed or applied, with a reference to the name of a decision, means that that decision was followed with or without a discussion thereof. Confirmed, it means that the case mentioned was accepted as good authority by a court which could have overthrown it. Approved. That the court accepted the other judgment as good authority without having been in a position to overthrow it, for example, because it was the decision of a different division. Overruled, it means that a court with the power to overthrow this decision has, in fact, done so, with the result that it can no longer be accepted as good authority, and dissented from indicates that a court without the power to reject the earlier decision nevertheless regarded it as incorrect. Not followed means that a court decided not to follow a decision. The reference to Oceancare Farms, Proprietary, Ltd Vitrio Transport CC 2002, 4, SA 483, SCA, serves as an example of this. Reversed means that an appeal has succeeded, and distinguished, that a court which would otherwise have been bound by a previous decision has, in some way or other, distinguished it, as described above, and therefore has not followed it. Compared and discussed, or referred to, simply means that the court brought in another decision by way of analogy, without necessarily expressing an opinion on its correctness. The reference to Traub v. Barclays National Bank Ltd., Koch v. Barclays National Bank 1983, 3, SA 619, A, is an example of this. Following the headnote there is an indication of the type of case, whether it is an appeal, an action, a review, an application, etc. This case is an appeal against the decision of Judge Kokelia in the Witwatersrand Local Division, now the Gauteng Local Division, Johannesburg, and his judgment was confirmed by the Supreme Court of Appeal. This is followed by the words, Advoca adv vult. This simply means, curia adversari vult, or, the court wishes to consider its decision. This is followed by the word postea, afterwards, the date on which the judgment was eventually delivered, and the judgment itself. The judgment ends with the order issued by the judge. If there is more than one judge, the name or names of the judge or judges who concurred, or differed, with the judgment are given, followed by the names of the respective attorneys. Further reading. A.B. Edwards, The History of South African Law, an Outline, 1996. D. Klein and F. Viljoen, Beginner's Guide for Law Students, 4th ed., 2010.